Good afternoon and welcome to today's program, The Future of ADR in Sports, sponsored by the Alternative Dispute Resolution Committee of the Entertainment Arts and Sports Law Section, co-sponsored by the EASL Sports Committee and the Dispute Resolution Section's Sports ADR Committee of the New York State Bar Association. If you would like to pose a question to the speakers, feel free to use the Q&A box in the Zoom portal. At this time, Kyle Beth Hilfer, EASL ADR Committee Co-Chair, will introduce our panelists and open the floor for discussion. Calbeth?
Thanks, Charmin. So I'd like to welcome everybody to this exciting program, The Future of Sports ADR, and we have a great panel assembled. Before I introduce the panel, I'd just like to encourage everybody who's interested to please reach out to me or my co-chair, Judith Prouda, the ADR committee of the Entertainment Arts Sports Law Section. It's a lot of acronyms there. ADR committee of EASL is currently active, and we are recruiting new members and welcome your ideas. We have exciting programming already scheduled for the rest of this year, and we'll be having a committee meeting soon. So if you want to get in touch with me, please do if you have questions about joining the committee. At this time, I'd like to introduce our panel for today's program, and I'm just going to go through it in alphabetical order. Jeff Cook is the General Counsel for the U.S. Anti-Doping Agency, where he leads the legal and investigative staff and the legal department's arbitration and legal cases. Cameron Myler is a member of the faculty at NYU Tisch Institute for Global Sports, where she teaches sports law and governance. She's also a U.S. OPC arbitrator and has heard cases in multiple forums. Jimmy McEntee is a senior associate at Hogan Lovells in Washington, D.C., where he spends much of his time working on matters for the firm's clients in the sports industry, including professional sports teams and university athletic departments. He's a leading practitioner for the Major League Baseball clubs in salary arbitration hearings as well. Casey Wallace has served as the Team USA Athlete Ombud since January 2015. She spent the prior 10 years mediating and doing a lot of great academic work. I'm sorry if I'm shortcutting any of your bios here as I summarize to get to the program. And Colin Williams is the founder and chairman of New Era ADR, and he will be moderating today's program. So with that, I will turn it over to Colin, and again, we'll be monitoring your questions in the Q&A.
Great. Thank you, Kyle Beth. Thank you to the New York State Bar Association for doing this. I think we're all really excited to be here. But primarily, thank you to this amazing panel. To actually get to listen to these folks is truly a special thing. So just full gratitude from me for you all taking part in this. So today what we're going to do, we're going to talk about the evolution of ADR in sports. And by the way, I have two monitors, so if it looks like I'm looking at the sky, that's why. We want to talk about the ADR's uniqueness, how it differs from ADR in the more traditional B2B and B2C contexts, where the panelists think that ADR needs to go to evolve and provide better solutions for athletes, organizations, NGBs, and teams. Just full disclosure, we're not going to be talking about more controversial topics like safe sport. That may be something that we do in the future, but for purposes of this, it's a very broad topic. There's a lot to talk about. It's probably by itself a 3 to 4 hour presentation. So we're not going to hit those topics today. Instead, what we're going to be talking about is more of a macroscopic view of ADR in sports, what we've learned so far, and where we think what the future holds. So with that said, once again, I'd just like to state, if you have any questions, please put them in the chat box. We will try to do a Q&A session at the end, but if that's not the case, we'll try to intersperse those questions as we go. And if you'd like a specific panelist to answer those, please direct that in the Q&A box to say, I'd really like Jimmy to answer this or whoever it may be. So I think that eliminates all the preparatory material. Let's sort of dive in here, and I'm going to start with Cameron. Cameron is our resident academic on this panel. She's also a former athlete, done a lot of incredible things. So Cameron, could you just give us a brief overview of how you've seen ADR become so prominent in sports?
Sure. Thanks, Colin. And thanks to everyone for hosting us here today. I am excited to be here with this um, exciting, accomplished group of panelists. So I guess one thing that wasn't mentioned in my bio that is relevant to my answer, and probably other answers as well, is that my first career was Olympic athlete. So I competed in 4 Olympic Games, and then figured out I had to do something after that. So law school sounded like maybe as much fun as luge. So that ended up being my path. But I mentioned that because I've had the opportunity to sort of see ADR evolve from when I was an athlete, and I competed in Olympics in 1988, 92, 94, and 98. Through that time, and then as a practitioner in my litigation practice, I represented some athletes in doping disputes and eligibility disputes. I now teach at NYU, and I'm on the Court of Arbitration for Sport as well as the USOPC panel. So I have. I'm thrilled. I think it's so important for athletes to have a forum to have disputes heard in a way that's fair, that's affordable, and that provides the flexibility that is necessary in the context of sport. And just for context, I retired before there was USOPC ombuds. So yay, Casey! I'm really excited. Excited to hear your perspective on this too. So before that, before the World Anti-Doping Agency or the U.S. Anti-Doping Agency were created, so I feel like there's been so much evolution, particularly in the Olympic and Paralympic context, as far as having procedures in place that allow athletes to get disputes resolved quickly and fairly, which is in everyone's best interest.
Great. So I'm going to jump to Jimmy here. Jimmy, you have an amazing background. Just so everybody knows, the fact that he does all these baseball arbitrations, it's just really staggering that you've created almost a monopoly on this. But I'm really curious, because you work at a large law firm, why is ADR so different in the context of sports than what you see in a typical B2B or B2C context? And just to give a little context to that, if you could talk a little bit about like the regulations, bylaws, constitutions that exist in all the different sports, and how that makes this sort of a mishmash where you can't do something that's very, very uniform across the board.
Sure, absolutely, Colin, and thanks everyone. It's great to be here. I'm glad to see some familiar names in the attendee list. So hello, and looking forward to contributing to the conversation today. And Colin, to your point, my background, I primarily work with professional sports teams in U.S. American professional sports, representing them in arbitration cases, mostly baseball and hockey and salary arbitration. I've also had the chance to work on some pretty high-profile, large-scale university enforcement actions before the IARP, Independent Accountability Resolution Panel, which sadly no longer exists. But I think it's hard to give a little bit of a sweeping answer for all different types of sports ADR, because whether you're talking about professional sports in the U.S., collegiate athletics, international Olympic type of ADR context, it can be a little bit different. But when we think about why ADR is different, just generally, and I'll probably focus more on professional U.S. sports in the sports context than maybe B2B, B2C. There's a couple of things that I think about. The first is it is really high profile in nature and can be challenging for confidentiality reasons, whether or not you want to keep the contents of those arbitration disputes confidential, oftentimes the result of which has to be publicly released, and the result of which it will be in the news by the nature of the dispute. If you're talking about a baseball player, their salary often gets in the news, and you've seen recently baseball players go to the press, talk about whether they like or dislike the arbitration process and how it unfolded for them. I think another reason why it's different is the efficiency point, which Cameron touched on a little bit on, and I'm sure we'll talk about more today. I think in sports, sometimes there's no option but to have the process go as quickly as possible. In baseball, there's about 20 to 25 salary arbitration cases heard over a 3-week period before spring training. And you just don't have the option to have a prolonged dispute that you might have in the normal business context. And then the final thing, and this goes to your second part of your question, are the rules that dictate. In the professional sports context here in the US, the arbitration procedures are set forth in collective bargaining agreements. So they're agreements between the labor and management, and over time can fine tune that process to make sure it meets everyone's interests. I think that also is a little bit unique relative to other ADR contexts when you're talking about outside the sports space, because while parties are fully aware of what the rules are based on what the collective bargaining says, if you're a player in the system that doesn't like the process, your only really avenue is to voice your concerns with the Players Association, who represents a number of different players and a number of different interests. And so you may not have the ability to change the process to your like in the way that you might when negotiating an ADR provision in a business transaction. So those are some of the ways that I view the context different. But of course, if you're talking about Olympic sports and the ADR process there, the answer might be a little bit different.
Well, that's a perfect foray, because now we're going to go to Casey. And by the way, just so everybody knows, the background on all these folks is absolutely insane. It would take up half of this and that's why Kyle Beth truncated it, but we will send it out so you can see what everybody in this panel has done, because it's really astonishing, which takes us to Casey. As we get into the Olympic world, Casey is the ombuds, which is a really interesting position because it represents athletes, and she can explain a little bit more about that. But my question, and I would love for you to explain a little bit more about what you do so everybody definitely understands, Casey, but my question relates to, why is a traditional adversarial process harmful to athletes? What are the detriments that ADR can kind of solve for?
Thanks, Colin, and happy to be here. And like Cameron said, just thrilled that ADR is now more prevalent in the sports world. As far as the ombuds role, our stated purpose, and it's a statutory position, are granted under the Ted Stevens Act, is to give confidential, independent advice to athletes and to assist them with dispute resolution. So a lot of our work is finding those alternative means to resolve disputes. And I think when you think about adversarial systems, to your question, Colin, most think about litigation, but if you consider an adversarial process generally to be characterized by two opposing parties who present their case to a neutral decision maker, and there's a winner and a loser, we do a lot of that in sport. Usually it's in the form of an arbitration or a hearing. But, in the spectrum of ADR, we tend to really impose a lot of the adversarial side of it. And I think it's really worthwhile to consider the full spectrum of ADR. Cameron mentioned the flexibility. Jimmy mentioned sort of fine-tuning the process to the interests of the parties. And I think there's a variety of processes and techniques that could be used to resolve disputes. At least in our world, in the Olympic and Paralympic world, this more adversarial nature, creates a lot of hardship for the athletes. It pits athletes against their coaches or teammates or those making decisions about allocation of resources or opportunities to be on a team. It often feels like an imbalance of power. It's quite costly for the athletes when you consider filing fees and legal fees and expert witnesses. The hearings are actually quite long and generally happen all day, often right before a competition when athletes are meant to be training. Again, in these adversarial processes, the focus is on a winner and a loser and not necessarily resolving the underlying issue, which may be unclear rules, poor governance, a mental health issue, or other circumstances out of the control of the athlete. And so I think all that generally leads to a process that impacts athletes' performance, their physical health, their mental health, and outcomes that perhaps don't fix the core of the problem. So, I think as we discuss this today, really looking at the spectrum of options and where we can yield sustainable outcomes that really benefit athletes is useful.
Yeah, and there's one thing I just in the context of the Olympics, so in case people don't know, this is something I've learned now that we're handling Olympic disputes. This is a very relatively closed universe of people who participate in these things. So if you could just elaborate a little on the fact that these are people that you're going to see again in disputes, coaches, whatever it may be, and why that's significant.
Yeah, great point. Every dispute happens in the context of a long-term relationship. And, I think if we can look at dispute resolution processes that pay attention to those relationships, whether it's with teammates or coaches or the governing body, trust and good communication are critical to athlete performance. And so I think incorporating those into a dispute resolution process is important.
Perfect. Now, Jeff, we're going to cruise over to you. Jeff has one of probably the most interesting legal jobs in the country as the general counsel of the anti-doping agency. I am curious in the context of anti-doping disputes, why is ADR a better way to go than, say, bringing an issue to court?
Thanks, Colin. I appreciate the opportunity to be here today and speak on this topic. Not to repeat everything Jimmy said, because he mentioned some of the factors, but they do apply equally as well to the anti-doping context. And so I just wanted to touch on 3 areas very briefly as to the advantage of ADR over the court system. There's the expedited manner of dispute resolution, which Jimmy alluded to. There's the confidentiality, and then there's also the specialized rules, and I'd also say specialized expertise from the arbitrators as well. So just with respect to the expedited cases, we had a case that came in on a Friday evening and was resolved by Saturday evening. And that's unusual, but the fact that that was even possible is pretty remarkable. And it's necessary in this context because there are team selection deadlines for the Olympics or Paralympics that are unmovable. And so when you have unmovable deadlines that are of the utmost importance to athletes, everybody has to work together to figure out a way to resolve any disputes as well as can be done in the time that you have. There's also, as I think most everyone knows, there's a curtailed discovery process, rarely necessitating depositions. And then our rules specifically require reasoned awards within 30 days, which is also just a nice to have, so that you're going to be getting that decision resolved by the arbitrator within a month of the hearing closing. With respect to confidentiality, in the anti-doping context, the process doesn't become public until there's a reasoned award issued that finds that a violation was occurred, unless the athlete makes it so, or the athlete's representative. So that's a unique aspect to arbitration that, of course, doesn't exist when you go to court. And then finally, with respect to specialized rules and decision makers with expertise, courts have routinely remarked how they are not well situated to make sport eligibility determinations. The federal judge that heard Lance Armstrong's case against USADA made that same remark when he dismissed the lawsuit. And that's why you have pieces of legislation like the Ted Stevens Amateur Sports Act that set out arbitration as the method for resolving these types of disputes. And of course, the Federal Arbitration Act, which makes it clear that these arbitration agreements can and will be enforced by the courts. So you have the specialized rules that apply, particularly in eligibility and anti-doping disputes. But then you have arbitrators who, like Cameron Myler, our former Olympic athlete, very familiar with the rules. And there's a whole panoply of arbitrators who are really experts within these fields and these very specific rules that apply. So there are all these advantages to going with the dispute resolution over and above the courts with respect to anti-doping and eligibility concerns.
I think there's a really important thing that you noted here, which everybody who's listening should. This is a very important part of the ADR process in sports, as opposed to a B2B or B2C process, where I was a formal commercial litigator where things could take years, right? And in this context, you're talking about athletes, particularly in the Olympic context, but certainly, Jimmy, I think you'd probably say in the professional sports context, there's deadlines. People have to compete. And if you're talking about somebody who's devoted their entire life to trying to make one competition, and you say, I'm going to have an adversarial process that may interrupt your ability to go do what you've been training your entire life for, that's simply unacceptable. So it really is interesting in this process that the deadlines are so short and things can be accomplished so quickly, but it's also absolutely necessary. It's not just kind of a convenient or interesting thing about this process. So we'll dive into some more stuff.
Colin, can I just want to follow up on a point that Jeff made and sort of emphasize the utmost importance of the speed that's one is able to have in getting disputes resolved through arbitration. And I heard one case that was just prior to an Olympic Games, and it was an anti-doping issue. I got a call asking if I was available to hear a case on an expedited basis it was maybe 1:30 in the afternoon. And I said, sure, I'm available. Like, what's going on? What's the timeline? I said, well, this is what's happening. And I can't disclose the details, but at the end of the explanation was, and you need to make a decision by 2 a.m. because that's a deadline for names to be submitted for the team, for the upcoming Olympic teams. So it was, less than, just about 12 hours from me hearing about the case to getting the information from both sides, conducting a hearing on the phone, and then realizing at the end of the hearing that I had 49 minutes to make a decision about whether an athlete was going to the Olympic Games or not. So there's no way, of course, any of that could be resolved in sports. So, incredibly important for all parties involved to have such a dispute resolution process in place.
Yep. Yeah, it's a really interesting part of this whole thing. And I think necessary for everybody to understand that this is a critical part of the process, the ADR process. And it's not just, once again, it's not sort of just a neat thing that these happen really, really quickly. It's absolutely integral to the fact that an athlete may miss a very, very significant competition, which will take me back to Casey. So when an athlete enters the dispute or grievance process as sort of their representative, what are their primary concerns and how do you think ADR helps those concerns?
Yeah, I mean, I think at the most basic level, it's fairness and respect. Affordable access to the process without fear of retaliation, procedural fairness, substantive fairness, and then respect for them as an individual in the context of their sport, and not only their sport, but their identity and their livelihood and everything else that's going on. This is not just a business decision. It is really determining their future. And so when you look at the nature of Olympic and Paralympic sport, most of the disputes center around eligibility and opportunity to participate. That might be team selection. It might be transgender issues or classification issues. It might be around adherence to a set of rules. And there are a lot of jurisdictional rules that apply to athletes, whether it's their national governing body, international body, the International Olympic or Paralympic Committee, as well as WADA, the Safe Sport Code, et cetera. And then you have a lot of disputes around access or rights or fairness to resources, allocation of resources. The disputes might be around safety and an athlete's ability to train and compete in a safe environment. And where ADR can help is really having this range of options to find those processes that address the interests of all the parties in a fair, affordable, expedient way. And how does it show up or what happens next? This depends. And the process for resolution can look very different for an athlete who violated the doping code versus a referee who had a conflict of interest, or whether an athlete's allowed to wear their sponsor on their speed suit or it has to be their NGB sponsor, et cetera. So, I think you need to look at these questions Jeff raised around privacy versus transparency. Who's on the panel? Is there a level of expertise? Are there conflicts of interest? Are they truly independent? Whether these hearings are in person or virtual, the speed, the cost, the consistency. So, there's a lot of things to look at in how to address just a whole host of disputes. We work across all 50 plus Olympic and Paralympic sport and on any sport related issue or matter. So one size fits all doesn't work as far as the dispute resolution process. And I think the more we focus on conflict coaching, facilitated communication, expert determination, peer review panels, mediation, online dispute resolution, in addition to hearings and arbitration, I think our system will be better and the athletes will believe in the system and be healthier for it.
You actually raised something that I think is very important for everybody to understand too, which is affordability. I think there's a little bit of a misnomer that when you think of athletes, well, they can afford this. It's no big deal. The reality is in like the Olympic context and in several other contexts, this isn't always athletes that perhaps Jimmy gets to deal with, right? Where you're talking about large contracts and a fair amount of money. You may have an Olympic swimmer who doesn't have a bunch of endorsements and doesn't have a lot of money to engage in an ADR process. So I think it's commonly misunderstood that people think, oh, well, an athlete who pays a part of this has plenty of money and it's not an issue. And the reality is they may be living on beyond a shoestring budget. And it makes it really, really difficult. And affordability is a huge part of that. And I'm happy if anybody wants to extrapolate on that, but it's just something that really hit me when you mentioned it.
Yeah, I'll make two comments on that, Colin. One is, this is really where the range of options become important because we can focus on those more affordable, less costly options to resolve a dispute. And when we get to hearings and arbitrations, I think within the Olympic and Paralympic movement, we've been given a gift to recognize how critical fairness is, due process is. And so our office manages a legal aid fund so that any athlete, any Team USA athlete who competes at a certain level can have access either to pro bono counsel or to up to $10,000 worth of legal aid. Now, that doesn't often cover the full extent, but at least it becomes more affordable for them to enter this process and have a fair shake at it.
Yep. We have a question. I'll get to it in a second. I won't miss you, Andrew. Don't worry. But I want to jump back to Jimmy and then we'll go back to Cameron. Jimmy, one thing I've always heard, we've heard repeatedly in these answers is the need for absolute efficiency in a sports ADR process. And I'm particularly interested if you can give us some examples and give us some examples in the context of pro sports and the stuff that you deal with, why that's important. I think we understand, if your Olympic trials are coming up, why it needs to be so fast. But I'd love to hear your opinion on why efficiency is so important in the stuff that you deal with.
Sure. And before I touch on pro sports, I'd like to talk a little bit about college athletics. And so we represented the University of Louisville and University of Kansas for the IARP, which was created as a result of Condoleezza Rice-led commission to kind of fix the enforcement process in college athletics. And what resulted was, I think, something opposite of the intention of the commission was very long, drawn-out investigations, hearing procedures. And so, for the University of Louisville, I think our hearing was around 5 years after the investigation started. And obviously that impacts when you have a hearing, when you have an ADR process, that impacts the athletes that were involved to begin with. But when you're talking about delaying this 5 years over time, now you're impacting the school at a totally different level. It's a cloud over the university's head. And to a large degree, the whole college athletics community prejudges that university whether or not the allegations were correct. And so when you think about efficiency and the importance, I think you can look at some of the things that have happened in the NCAA space for reasons why efficiency is so important and how some of the IARP's intentions failed. Now, in the pro sports context, I think it's very similar to Olympic sports. Efficiency is absolutely important. Whether you're talking about salary arbitration disputes, which is my primary area of practice in professional sports, you have to resolve those cases before the season starts, with the exception of the year there was a lockout when there was no option to do that. The salaries have to be determined before the season starts. And as a result, baseball and the Players Association for the last 60 years have developed a process that gets results to the parties generally within 24 hours. They went from having full legal briefs as recently as 10 years ago to now there's no more legal briefs in the process, in part to kind of get to the core facts, the core issues as quickly as possible. There's no written opinions. The arbitrators pick one number or the other. And to your point about efficiency, I think both parties realize that the arbitrators can get to the right outcome. They can get to the desired outcome of the parties in a clean, quick way that everyone relatively wanted. Now, there's pros and cons to having no written opinions. There's pros and cons to limiting the submissions by the parties prior to hearings. But when you're talking about a process where everyone wants to get past, to get the season started, to go to spring training and things like that, baseball has developed, I think, a pretty quick, efficient process and can have as many as 20, 25, 30 hearings in a 3-week span. And so that's just the salary arbitration context. When you're talking about grievance disputes, the same is true. Some things that have happened recently in high profile and professional sports are league-led domestic violence investigations. So investigations outside of the criminal context where the league is taking upon itself to do an analysis about whether an instance of domestic violence occurred and or just a general violation of league policies. And it's in everyone's interest that that investigation happen quickly and fairly with due process for the parties. But especially from the league side, wanting those to be resolved quickly is of the utmost importance. So no matter whether you're talking about the salary arbitration context I deal with, or standard grievances, whether it's a drug type grievance or a DV type investigation, I think everyone is interested in getting these resolved as quickly as possible.
Makes sense. I'm going to jump to Cameron and then Jeff again, but I want to get Andrew's question answered. And he didn't specify anybody, so anybody who wants to take this is welcome to it. But to what extent, when we talk about ADR, are we talking about mediation versus arbitration? And I think this is actually a really interesting question, probably not a really simple answer, but if anybody wants to take that, that'd be great. No one? I'm happy to.
I'm happy to.
Go ahead.
Again, I think it's not an either or. I think it's considering the spectrum of alternative dispute resolution. And I think mediation is one of those options. From an ombud's perspective, my background, I used to have a mediation practice, and it was very formal mediation. I think in an ombuds practice, it's usually facilitated mediation or facilitation or shuttle diplomacy and going back and forth. So I'd say 95% of the work that we do is in that context of intervening and helping to resolve communication issues. Only the very top end of disciplinary issues, athlete rights issues are resolved through hearings or arbitration.
Yeah, and I would just throw in it may also be a creature of whatever the bylaws or the Constitution or the rules of the sport apply. Maybe there's a mandatory mediation process, maybe there's not. Maybe that's required before you go to arbitration. It may very well be dictated by whatever rules apply. So now we will go to Cameron. I've got you here somewhere. You're a professor. So this is a really interesting thing. When we think about the future of what ADR looks like, how do you think you can best teach dispute resolution to law students? How do you get them ingrained in this? How do you get them involved in this?
So maybe just to be clear, I teach in the Tisch Institute for Global Sport at NYU, which has an undergrad degree and 2 master's programs. So while many of those students might go on to law school, I'm teaching students who are not yet there. So I think it's actually really important in the context of what the students learn. And I teach. I'm usually like their first contact with a law class in the program, and sports law is it's a survey course where we talk about everything from contracts and torts to antitrust, labor law, IP, and doping, and ADR. So the students that I teach, we have a very international cohort, both undergrads and grad students, and they might go on to do a whole variety of things. Maybe it's law school, but even if not, if they're going to work as an agent representing athletes, or maybe for a team or a league where you're dealing with the salary arbitration perhaps, or another type of arbitration that's dictated by the CBA. It's relevant to know the basics of what it is, what the benefits are, how it's different than going to court, and how how it might come up in the context of one's professional work. So yeah, I feel like I have a lot of freshmen who are like, I want to be an agent. Like, come talk to me in a couple of years, and let's see if that's still what you want to do. But ADR, whether what we've been talking about here, it dispute resolution of doping issues or eligibility disputes, or maybe it's an endorsement deal that an athlete has with a brand, and they're negotiating how disputes get resolved. I think it's really critical for students to know what the options are. So I love teaching the classes that I do because, as I said, it's oftentimes their sort of first contact with a law class, and it's great to see them like excited about what their professional path might be and how law might intersect.
Yeah, I have a friend who is a baseball agent who would caution anybody about wanting to become a sports agent.
Mhm.
Jeff, I want to jump to you, particularly because USADA covers some. So this gets to the complexity of ADR and how difficult it is to administer things. When we talk about USADA, how many different organizations actually are subject to USADA? How does that come about? How do you become subject to USADA's rules? And what issues does that present when you're resolving disputes?
So there are about 63 national governing bodies for sports in the United States under the Olympic and Paralympic and Pan Am and Para-Pan Am umbrella that are subject to USADA's rules. The mechanism by which they are subject to USADA's rules are, since they're under the U.S. Olympic and Paralympic Committee umbrella, I'll call it, then the USOPC's anti-doping policy applies to them, which then requires them to implement the USADA rules and to have it implemented through their bylaws or through membership agreements or some other mechanism so that it applies to all the participants in their sports. So that's the primary way that our rules apply to all of those sports. We can also contract with entities to apply either the USADA protocol, or we also have another set of rules that's a bit more flexible and based on an earlier version of the World Anti-Doping Code. So there are a couple different methods that rules can apply to athletes. I'd say with so many different sports applying our rules, the major issues that we face are really getting information quickly about the upcoming major competition in each of the sports, because it differs based on the sport, and also ensuring that we're educating the athletes who are most likely to be tested, who may cycle through at various speeds depending on the sport. And so I mentioned the USADA protocol, which is our set of rules that adopts the World Anti-Doping Code, and that rule set's very much geared towards sports that fall under this Olympic Paralympic umbrella, because the default sanction for a serious doping offense is 4 years, and that was designed to ensure that those athletes were kept out of one Olympic cycle. So for sports that that fall in that Olympic Paralympic umbrella or want to, it makes a lot of sense to apply that set of rules so that it will be consistent should that sport be selected for the Olympics or Paralympics. But like I said, we do have another set of rules that we've developed that's more flexible and has a default sanction that starts at 2 years rather than 4, and so may be more appropriate for non-Olympic, non-Paralympic sports.
Got it. Casey, I'm jumping back to you. And here we're really going to dive into what the future looks like. So I'd love to hear if you can tell us how a typical dispute or grievance comes about in a USOPC dispute and what could improve that process. And I'm particularly curious about technology and what role you see technology playing in the future of ADR, particularly with respect to the USOPC disputes that you handle.
Yeah, so how it comes about, 50 plus sports, athletes at all levels, it depends. It could start with a particular incident or circumstance, maybe being left off of a team or not getting access to certain benefits or services. Maybe they've been accused of something like in the doping context or safe sport context, or even a policy or practice that they might consider lacks integrity or fairness. And so at that point, there's any number of recourses that an athlete might access. They might ask a trusted resource, whether that's a teammate, friend, parent, coach. Hopefully they're coming to our office for independent, confidential advice. They might confront the individual. In some cases, that's really constructive, in others not. They might post something on social media about that person. They might file a grievance report anonymously or not. Or in many cases, they do nothing, either because they don't know where to go, what to do, or fear retaliation. And oftentimes we see these issues manifest in other ways, whether it's mental health, illness, performance issues. So, a whole host of things. And your question about what could improve the process, I think on the front end, investing in a system with better options around prevention, mitigation, and resolution. In our office, we really want to drive empowering athletes to problem solve for themselves where they can, and then access to counsel or representation when they need it. So we need greater visibility of all the resources. Athletes are cycling in and out all the time, and visibility is always an issue. And then I think generally a feedback mechanism to assess how our conflict management system's working. Does it align with the values of the movement, et cetera? And the role of technology, I think technology could be used in many different ways. One, to empower the athletes with knowledge and information, skills, how to effectively understand their rights, their resources. It could be used to improve the ability to collect or exchange information across athletes and entities. It could be used to enable this feedback mechanism that I mentioned. It could be used to identify trends that we aren't seeing, or we're simply noticing anecdotal information. And then I think it could be used to resolve disputes, online dispute resolution, or various aspects of technology. And I'll mention one interesting case that we had recently of an athlete accused of an anti-doping situation who put together his whole defense through ChatGPT, did not want to hire an attorney. And it wasn't so far off the mark. There were some inaccuracies in his defense that he got through ChatGPT, but I think it's coming. I think we all need to embrace it and figure out how to use it to serve as opposed to fear it.
Makes sense. Cameron, I'm going to jump to you. It's kind of the same question as a former athlete, current advocate. What do you see as the future in ADR to sports? And I'm curious to get your take on the use of technology.
And so I was laughing at the ChatGPT example, but like it's true, it's here, and I am proactive about using it in the classroom, but as a starting point, not to the end of one's analysis. So, Casey, really interesting to hear that that has come up in that context. But given given the cost of lawyers that athletes have, need to hire to represent them in disputes, $10,000, which is like amazing that they get any kind of monetary support. That's it doesn't necessarily go a long way. So really great use of technology, innovative. I think Casey mentioned using technology in the context of of dispute resolution itself, and I think the post COVID in this post COVID world, so many more of our meetings and contacts and abilities to interact with one another happen very easily online and in a context like this. So I think it actually benefits athletes in a number of ways. One, disputes can be resolved even more quickly if we're all meeting online, and you don't have necessarily the extra cost of having to go to a place to have a hearing. So I think a lot of the technological evolutions that we're seeing are definitely going to benefit athletes going forward, and others too, of course.
And just to follow on, it's not so much related, but you have a particular expertise, which I think everybody should know about, which will lead into this next question, in that you've actually been involved in a dispute resolution process at a major sporting event, which was the CAS anti-doping at Pyeongchang. What does a dispute process look like during a major sporting event, and how do you think that can be improved in the future?
Sure. So I was on the anti-doping division at the Winter Games in Pyeongchang, and since for a little context, since 1996, the Court of Arbitration for Sport has been the entity designated to hear and resolve any disputes at the Olympic Games. So there are no more. You can't run to court to try to get an injunction or something of that nature. You're going to CAS, and because at the Olympic Games there is certainly a need for speed and resolution of any issues that may come up. Generally, any decisions have to be issued within 24 hours of a hearing, but oftentimes they happen even more quickly than that. And CAS has broadened sort of its coverage at not just the Olympic Games, but like the FIFA World Cup and other Commonwealth Games and other major sporting events. So now there is at the Olympics anyway, there is the ad hoc division and the anti-doping division, and we heard, I was on anti-doping. We heard there were actually of the 3,000 plus tests conducted in Pyeongchang, there were 5 positive tests. And the ad hoc division decided everything else, which was and may still be for some time ongoing. Russian athlete eligibility. Can athletes, actually are they able to compete even though the country's banned from participating in the Olympics? So from my perspective, I thought everything ran really smoothly. Like the case I was assigned to, was assigned a couple of hours before the closing ceremonies. It was a Friday night, and we worked kind of through some of the night, and by the next day, the athlete had agreed that she had committed an anti-doping rule violation. She was disqualified from her event, and she was on a plane home. So it goes quickly. There's a lot of support from CAS, from the staff council and others. But yeah, I don't know what, and maybe Casey or Jeff have thoughts on how it might be better. But I think it worked quite well from my perspective. And I think another sort of important element of that is in the host country that there are lawyers sort of who do training in advance and are available to help athletes who might have a case and not necessarily have access to or know how to find someone to help support them through the process.
Got it. So we've reached 10 minutes to go. I'm going to finish this by asking you all the same identical question. And I'll hop to each of you just to get your thoughts sort of on what the future of ADR looks like. If anybody has a question, type it in so I can get to it. If not, that's totally fine. But we're going to hit the end here pretty soon. So I'll start with Jeff. The question is, what opportunities and or challenges exist today in advancing some of the ideals that we've talked about?
I'll give one opportunity and one challenge to keep it brief. So opportunity, just sticking with the technology theme and AI, I think there's a real opportunity to use AI to assist parties, particularly pro se athletes, who we can help bridge the knowledge gap regarding the substantive rules and the potential outcomes in a case, because that, in my estimation, seems to be one of the biggest obstacles once a case is initiated, just because of how specific the rules and regulations are in this space, is bringing the athlete fully up to speed with the picture and outlook of their case. With respect to a challenge, one of the biggest challenges, and I don't know that it's going away anytime soon, but I can dream, is the fact that we have de novo appeals in all of our anti-doping arbitrations. I would love to get to the point where the rule makers, which is not USADA, but the World Anti-Doping Agency, could have sufficient confidence in the experience of first instant arbitrators, however they can gain that confidence, that there would be a more limited basis for appeals, which would make the process more streamlined.
Makes sense. Jimmy, I'll hop to you. Same question. What opportunities and challenges exist today in advancing some of the ideals we've talked about?
To piggyback off of some of our recent discussion, I do think AI has a pretty big role in professional sports moving forward. And when you think about the process that I'm involved in, salary arbitration, it's an either or decision for the arbitrator. So the club files a number, the player files a number. You can imagine $3 million, $4 million. Well, it's pretty easy to design an algorithm to figure out, what that algorithm thinks is an appropriate salary. And for reasons that are maybe too long to discuss here, it appears that some parties are not interested in that process, not having an algorithm guide the discussion. And I think there's a lot of not only interesting practical elements there, but also some interesting ethical elements about who's designing these algorithms, who's creating the AI that could guide, whether you're talking about salary arbitration or other processes, and what are the inputs going in that result in the outputs, and who's benefiting from that. So I think moving forward, these issues are not going away. We're probably just starting to think about AI and its role in resolving or potentially resolving arbitration dispute type processes. And I think the ethical component about who's designing those systems and creating them is an interesting tangent to think through as well.
Cameron, I'll shoot the same question to you.
Okay, so Jeff's response prompted a thought for me. So I think one challenge which provides potential opportunity is the sort of lack of a central database for arbitration decisions in Olympic sport cases. So whether it's USADA related cases or USOPC or decisions from CAS, I wish they were all on Lexis or Westlaw or some other place. And Jeff, to your point of sort of bridging using AI to bridge the knowledge gap for pro se athletes, if all of those things were in one place, all of the decisions and rules and all of that, I think it would be like amazingly helpful and more efficient.
Makes sense. So Casey, you get to polish this up here and finish the whole thing off.
Great, thank you. I mentioned at the most basic level, athletes are looking for fairness and respect. We've talked a lot about fairness, and so I think I'll hit on the respect issue and the infusing and a very intentional attention to the well-being of an athlete in this process. There have been a lot of consequences because of the mental health side of this. And one mediation I did that sticks in my mind is we had been mediating between an athlete and a CEO over a team selection issue for about 10 hours. And the athlete threw all the dishes off the table and said, I'm out of here, I'm done. For him, this is a business transaction. For me, this is my life. And I think infusing that reminder that this is really about an individual's life and identity, and finding ways to simplify this complex ecosystem, educate and empower athletes is important in the balance of fairness and respect.
Love it. So we don't have any other questions. We finished 4 minutes early. Kyle, Beth, I don't know if there's anything you would like us to do. I would just like to personally thank the panelists for participating. You guys were fantastic. I expected nothing less, but was even more surprised at how great this conversation was. So thank you guys. Really, really appreciate it. I will turn it back to Kyle, Beth.
Yeah, thank you. And thank you to the panelists. I do have one question that I'm going to address to Colin, who's been very shy about New Era. I appreciate all the insights that everybody gave into this complex ecosystem. But I think since we have 2 minutes or so left, I would love to hear a little bit about, how New Era is addressing some of these challenges, and what might be on the slate that you can discuss.
Yeah, just for everybody who doesn't know, New Era is we're a technology-enabled ADR platform. And our goal is to truncate the process, make everything more efficient, make it less expensive, provide better access to whoever it might be, whether it's an athlete, a consumer, an employee. The way we see the future is a lot of what people have talked about. I do think the AI question is really, really interesting. I think we still live in a world where people want to tell their story to a person. So I'm not sure how that all interacts with AI going into the future. But I think there's a very cathartic moment, and Casey could probably talk very well about this, where say you're an athlete and something's happened to you, and you talked about how this is their life, and they want somebody to hear them, right? So even if it goes against them, certainly they're not going to be happy about that. But if somebody's heard their story, then maybe they feel a little bit better about a decision that comes down one way or the other. So for us, we're trying to use technology to enable access, to make everything easier, to make sure that people can do it from their home, that they don't have to travel. But we're also trying to infuse that human element where people have somebody who will listen to them. And I think, from my experience in litigation, you never really got to that point. So you would really go through this whole process and end up settling, and somebody would say, why didn't anybody hear my story? So for us, we think it's critically important that the person has the opportunity to actually tell what happened. And whether the decision goes their way or it doesn't, there is that catharsis of saying, all right, somebody at least heard me. So once again, we're sort of a mishmash of technology while also maintaining that human element.
Thank you. So again, thank you to everybody for this terrific panel and participation. And if anyone wants to listen to it again, it'll be housed on our committee's web page, and we will also be posting in your learning dashboard some the bios, as well as some materials that were put together for you. So please don't hesitate to look at those. And if you have follow-up questions at all, you can reach out to me or to any of the panelists through, I'm sure they're easy enough to find for your follow-up. So thank you everybody for attending. And thank you to the New York State Bar for hosting, and we'll see you all soon.
Thank you.
Thank you.